Hello, I'm Louisa Deaver from Seratium, and thank you for joining us today for the second of our expert-led webinars, which have been organised as a joint initiative between Seratium for the Capitalised Project and Euroseeds. The webinars are specifically aimed at the plant science community. So today's webinar is on intellectual property, and although intellectual property plays a crucial role in translating plant science innovations, it's something that researchers don't prioritise or don't seem to prioritise, and this is that their awareness is actually quite limited. But if you want to unlock the potential of your research and not have it left in dusty academic journals never to be used, then you really need to be aware of IP and how to use and what you need to do. So today I'm delighted to welcome Francesca Garbato from Euroseeds to talk to us about intellectual property, and to introduce her, I'm going to hand you over to Nick van Geloo from Euroseeds. Over to you, Nick.
Thank you very much. We are really pleased with this webinar, as we think as Euroseeds that this is a very important aspect. So a couple of slides, how we can facilitate research uptake by the seed and plant breeding sector. So we are Euroseeds, the European Seed Association, and we consist of direct company members as well as national member associations from Europe and beyond. And so what I would like to highlight here for anyone active in plant research, that the R&D budget and the strategy of a business, in the end, it depends on the crop specificities, the market size, but also the regulatory frameworks that apply, as well as the technology readiness of the crop. So if you aim in your research activities to develop a new plant variety in the long run, you actually need to consider many different aspects besides the actual biological research in your R&D process. And so here we depicted many of the different aspects, such as access benefit sharing obligations that might apply, phytosanitary requirements, are you aiming for the organic seed market or not? And also, is there what kind of intellectual property protection might be already present or existing? And how could you make use of a kind of protection to guarantee a return of investment? So these are all different aspects that we need to consider. And this is what we try to highlight in the projects that we're involved in. Because in the end, thanks to the multi-actor approach, we as an industry, as the private seed sector, are happy to collaborate and fill the gap that there often still is in the transition from more basic research towards more applied translational research, and then integrated in the actual company research, where then can be made use of their tools and technologies for the variety development and the variety listing and marketing. So this is an important aspect, and this is also highlighted by the Commission. This is dedicated in their valorization policies, so the exploitation or the making use of the results. And together with my colleagues at the Euroseeds team, we are dedicated to help this innovation transfer process and also to promote that. So that's why I'm very pleased today to welcome Francesca, our colleague. She is the IP and Legal Affairs Manager at Euroseeds. She has a Master in Law from Bologna, and then furthermore 2 LLMs from the Netherlands, Tilburg and Maastricht. And she has worked at several international companies. The last one before she joined Euroseeds last year was Johnson & Johnson. And so I'm looking forward to understand better what different IP systems are available relevant for the plant and the seed sector. And we're looking forward also to your questions afterwards. Francesca, the floor is yours.
Thank you, Nick. Thank you very much. Thanks for inviting me today. So indeed, my presentation will be about IP in general, and then more in detail, which intellectual property systems are available for plant research and breeding. This is the basic set of information, so it's basic education. If you want to know more, indeed, I would be happy to receive questions afterwards, but I will really be trying to highlight the general concepts. Okay, so we can start. This will be the outline of the presentation. So I will say a couple of words about Euroseeds, although Nick has already done part of it. Then what is IP? Some history, why IP is important, and then why it is important in our sector. What types of IP are available in general, and then more in detail, plant breeders' rights with the legal framework, requirements, scope of protection, exceptions, and process, and then the same for patents, and then some short words about our Euroseeds position. Okay, so about Euroseeds, we are the single voice of the entire European seed sector. Nick has already indicated who do we represent. Here, I just want to say that the importance of this slide is, of course, that once you realize the diversity of our membership, you will also realize that the IP protection type chosen by each of them is different. And you also see that IP is part of our mission. What do? We inform, represent, and advocate on all seed related issues. You have a list here, and you see that intellectual property rights are among them as well. Who we work with the European institutions, particularly relevant for intellectual properties, the CPVO, and I will talk about it later. But we are also observers in many international organizations, some of which you see here, UPOV, we will discuss it later, are intellectual property rights organizations. We are also in contact with many other stakeholders. So now we go to the real content, IP. I will start really from the basics. So IP is a very broad concept, and if you would ask what is IP, you could get a different answer depending on where do you ask it and what do you want to protect. That's why I've decided to start really from the basis, so from the Declaration of Human Rights, because it's important to realize that IP is mentioned as a human right. So as the right to the protection of the moral and material interests resulting from any scientific, literary or artistic production of which is the author. So you see scientific production. So that's research is part of it, and this is really important because this is the most basic concept, but also the most important. It's a right that we all have. Then I think we should look at what the World Intellectual Property Organization has indicated as definition for IP. So IP refers to the creation of the mind, everything from works of art to inventions, computer programs to trademarks and other commercial signs. Again, you see how broad is the concept, but you see how important it is. So ultimately, we can say that IP is a monopolistic right. It has a limitation in time, and we will see this later. So it's not a right that one has forever without any limit. It is monopolistic, as I said, and it involves the invention. So the subject matter that you want to protect. It also always results in the exclusion of others to commercialize or use for industrial purposes the object of what you are protecting. So there is always a right and an exclusion. Before we continue, I just want to say some words about the history to say that this is not new. So plagiarism already existed when Cicero, at Cicero's times. In the Magna Graecia, 1 year of monopoly for culinary recipes for chefs was granted, so that's IP protection. The first patent was granted to Brunelleschi in the Renaissance, and we already have the first example of a patent system with the Venetian patent statutes from 1474. And here we even already see a definition of the requirements for patentability and for IP protection in general. I've put a picture because I find it quite fascinating to see that this is really not new, what we will be talking about. So now we'll talk about why IP is important, and then why IP is important in our sector and in research in general. So maybe before I go to that, I imagine that, so I know that some of you or most of you are researchers. I imagine that the most fulfilling and exciting aspect of research is innovation. But when you innovate, you should also be aware of the rights that you have as innovators and about the consequences in terms of benefits of innovating and disseminating knowledge, giving access to what you create, but also gaining return on the investment made. And that's where IP plays an important role, because while IP benefits society, the reason is that it contributes to sharing and access. So it also contributes to public interest because it makes the technological developments available, of course, on the market. So this means that more people can access the technology, more people can access the what is being developed, but it also benefits innovators, and that's all of you. Why? Because it provides return on investment and recognition. And the reason of that is it provides the exclusive rights that I mentioned earlier to commercialize your innovation for a certain amount of time, which also means that it provides a way to, again, recover the investment made, both in terms of time and in terms of finances. It's also important for the point of view of the reward, again, monetary reward, but also reward in terms of recognition. When you have your IP right, then you can safely publish your research, and you can safely make use of it and further develop it. IP also encourages innovation and creativity. Again, it's an incentive, and it's a way to disseminate knowledge in a safe and fair way. Now, it goes without saying that all these benefits cover different aspects of society, and they need to be very well balanced. So an IP system, in order to be efficient and effective, needs to well balance all these elements. So on one side, society, on the other side, of course, innovators. In this context, why is IP important for plant research and breeding? So the products of plant breeding are of very high value. It takes a very long time to develop them and quite some R&D investments. But what is peculiar in this sector is that the products are self-reproducing. That's really unique, and that's why a strong IP system is needed, strong protection, because otherwise, the innovation is lost. So IP is important for the fair return on all these investments, and it should really be taken into strong consideration. So ultimately, before we go into more details, what I want to say is that for breeders and for researchers in general, when there is such an investment of technology, expertise, money, time, IP is the best and most appropriate solution. So before we discuss what types of IP are available, I want to mention a more general concept, and here we go more into the legal aspects, which I know are not the most important for you, but they are very important to then understand how to best protect your inventions or your innovation. When we speak about IP, there are always three levels of protection. The international level, the regional level, which for the purpose of this presentation will always be the European one, and the national level. So both from the point of view of the legislation and of the territoriality, so where you would seek your protection, we always have to consider three levels. So at the international level, there is one agreement for intellectual property, and I will mention it later, that sets the minimum standards for all the member states. There are then implementing conventions and treaties that change depending on the type of IP that they refer to. Then there is always European implementing legislation, and then there is national legislation. When you would want to enforce your IP rights, so if your IP right would be infringed, then you would always have to go at the national level. So that's important to keep in mind, because there are, of course, many differences between national legislations. When you would have to litigate a case because your right has been infringed, then it's always the national courts. Few exceptions that we will see later. So this is important because in this presentation, you will always see that I refer to these three levels. It's also important to know that as innovators, you will have the choice of where you want to apply for an intellectual property right. So you will always have to know, depending on your business model, depending on your, of course, also financial possibilities, whether you want to protect your invention at international level or only at regional level with one right that is valid throughout, in our case, throughout the European Union, and we will see that later, or whether you only want to protect it in one country. Okay. So what types of IP are available in plant research and breeding? So the two most used and most suitable IP rights are plant breeders' rights and patents. But I think it's also important to take into account that trademarks, copyrights, and contracts play a role. Okay, contracts are not really IP rights, but they need to be taken into account by all of you. I also want to highlight that copyright do include, under intellectual property, they do include computer programs and databases in general. So I have created this chart. You will receive the slides afterwards, so I will not go too much into details for every tab. But what I want to highlight here is that it's important to know that depending on the IP that you choose and that it's relevant in your case, you will always have a different scope of protection, different requirements for grant, a different duration, different responsible bodies when it's about both legislating but also deciding whether you are entitled or not to your right, and different legal bases. So PBRs and patents will be the subject of this presentation, so I will skip them for now. Trademarks. So for trademarks, we mean all the types of signs. I've put some examples here. The requirement for registering a trademark is distinctiveness. The duration is normally 10 years. And the legal basis are TRIPS, which is the international agreement setting the minimum standards, some other international implementing conventions, and then the EU legislation. For copyright, a distinction needs to be made on the scope of protection because copyright can refer both to creative expression of ideas, so original works, but also to databases, as I said earlier. So I think all of you work with databases and software developments, then copyright needs to be taken into account. The requirement is originality. It has quite a long duration. And yes, the legal bases are indicated here. Now, one last thing are contracts. Of course, rights can also be defined in contracts. That's different than having an IP right that can be enforced against any third party. A contract is only between two parties, so that's a big limitation. But of course, it might be less expensive than registering an IP right. Okay, so now, before we go on, I want to give some background on the current discussions and on the background of plant variety rights and patents. So plant variety rights and patents have two different scope of protections. So you see plant variety rights are for the plant variety itself, so the phenotype resulting from the combination of genetic, and patents are protecting the genes as such. In the past, in our sector, the situation was rather straightforward in the sense that the plant variety rights and patents were not interacting. So on one side, there was the protection of plants, the variety. On the other side, there was the protection of the technology, the gene. And so there was this distinction, clear, no issues, and the system worked very well for many years. Now we have to take into account that with the technological developments that we are facing, first and foremost, NGTs, so new genomic techniques, the system cannot be taken like these in two separate lots, but we have to look at the interface and how these two rights interact, how these two IP systems can be balanced, and in general, at what can be done to have the balanced system that I spoke about at the beginning. So we will start with plant breeders' rights. Okay, and with, again, I am sorry for these, some words about the legal framework. So it is important to know that the minimum standards set by TRIPS agreement again is the agreement that sets the standards to then be implemented by the member states. For plants, it states that members shall provide for the protection of plant varieties either by patents or by a sui generis system or by a combination. Now, in Europe, this has been implemented as a sui generis system, so you cannot patent a plant variety. So not only it has been implemented as a sui generis system, but it has also been excluded from patentability. In addition, you cannot have a combination because the two systems are not, so you cannot patent and have a plant variety on something at the same time, so they are not cumulative. Our European system is based on the UPOV Convention. I don't know if you know that UPOV is the International Union for the Protection of New Varieties and Plants. It's an intergovernmental organization and it has 75 members. Europe is one of them. So Europe has implemented the UPOV Convention through what we call the CPVR system. So the CPVR is a system managed by the European Office for Community Plant Variety Rights. It's set out in what we call the basic regulation. So it's regulation 210094. But what is important here is that this is a system that provides the possibility to have one right valid throughout the European Union and administered centrally by the CPVO, meaning you pay and you apply for one right that is valid at European level, and that is examined only by one office. Second possibility at European level is what I said earlier. You can also apply for a national right, and then it will again depend on where will you apply for your right, what you are looking for, how much finances do you have. But you have to know that then it will be examined at national level, and you will only be able to enforce it in one country, of course, in the country in which you apply and in which your right is granted. So what can be protected by plant breeders' rights, and which are the requirements? What can be protected? So the subject, I've already said it, it's a plant variety, so a specific phenotype, but there are some requirements for this phenotype. And these are that it should be new, distinct, uniform, stable, and it should have a suitable variety denomination. Now, why are these requirements important? Because these are the requirements taken into account during the examination of the request for having the right granted. And these are different depending on the IP right that you're applying for. So you will see that there is quite some difference from the patent requirements. So it should be new, so novelty. For novelty, we intend prior use by self-anticipation. Again, I will already anticipate that that's a big difference from patents where there should be absolute novelty. So here it should really be only, or it's sufficient that it is prior use by self-anticipation. Then distinctiveness, what we mean here is that the variety should be distinct from any prior art. And for prior art, in the case of plant variety rights, we talk about previous applications for grant of a right. Uniformity, so the applicant should show that the plant's characteristics are sufficiently uniform. And then stability, so the applicant must show that basically the expression of the characteristics that are included in the examination for distinctiveness and for the description remain unchanged after repeated propagation, or of course at the end of each cycle of propagation. And then the variety should be, the variety denomination should be suitable. So please keep in mind this DUS because it will come back later when we talk about the process. Plant breeders' rights, the scope of protection. So there should be, once you have a right granted, authorization required by the right holder for production and reproduction, multiplication, conditioning for the purpose of propagation, offering for sale, selling or other types of marketing, exporting, importing, and stocking for any of the purposes that I just mentioned. And plant breeders' rights give the exclusive right to the owner that extends to these organic materials. So I will not focus on each of these because probably you are very familiar with them. But what I want to say is that I indicated here EDVs. So these are essentially derived varieties. So these are varieties that are essentially derived from the variety in respect of which the right, so the CPVR right in Europe, has been granted. Okay. So which are the exceptions? This is a very important point. So private non-commercial use for research, use for further breeding, and use as farm-safe seed. Again, that's important because this is very special to plant variety rights. So we will discuss it later. You will see this is different from patents, but the plant variety rights, particularly in Europe, ensures that the innovation is not blocked, that the innovation is accessible. So here in this slide, you really see the application of the concepts that I spoke about when I said why is IP important and why does it benefit both society and the innovators. You see it here. So the right holder has the right to exclude anyone else from the actions that you see at the left for the material that you see here at the right of the slide, but the material can be used for private and non-commercial use, for further research, for further breeding, and as farm-safe seed for the use, for the own use of the farmer. I will not go into details of all of these because it would probably be too much for this session, but the details of these exceptions, sorry, I didn't mean to switch the slide, are outlined in the basic regulation. So when you will be receiving the slides, you will see that when I indicated the number of the regulation, if you click on it, you can go directly into the text and then you can see all the details. The process, so if you would want to apply for a plant variety right, depending on, of course, on where you are applying for it, we said you can either apply at a national office or you can apply in Europe at the Community Plant Variety Office. You have to submit an application. The application will undergo both a formal examination and a technical examination. The formal examination is really on the completeness of the documents submitted. The requirements are outlined in the basic regulation and then in the explanatory one. Then there will be a technical examination. So the variety will be examined against the closest reference varieties, and the requirements will be the US, so the requirements that we saw earlier. Once the US test is concluded, a report is drawn up. Maybe it's important to say that if you apply for a Community Plant Variety Office, there will be the entrusted examination offices. The advantage of this system is that indeed applications are examined in the same way for everyone applying to the right. And then on the basis of the US report, a decision will be taken to grant or not to grant a title. To be noted that there is an application fee, there is an examination fee, and there is also, once the title is granted, there will be also annual fees to be paid in order to keep the right alive. Plant variety rights fees are much lower than patent fees, I have to note here. Okay, so I think that's almost everything I wanted to say for plant variety rights. I say almost because we will come back to them at the end of the presentation. And we will now talk about patents. Oh, sorry, I didn't need to have it distributed in this way, but okay. So I want to stress here that for patents, I am limiting the legal framework to the European one, because if I would go further than that, we would have to stay here much longer than 1 hour. This being said, the minimum standards are still set by TRIPS. So it's the same TRIPS agreement for IP. And there is a convention, so it's the Paris Convention I have indicated in the table earlier, that sets the standards for the member states of the World Intellectual Property Organization. But Of course, we are in Europe, so let's focus for now on the European framework. So at European level, there is the European Patent Office, which administers the application and implementation of the use of the European Patent Convention, what we call EPC. The European Patent Convention has member states that are also beyond the European Union. So when you would apply for a European patent, what we say, we call it EP patent instead of EU patent, then you would have protection further than the European member states. Then there is European implementing legislation. So very important in our case is the Biopatent Directive, which provides for protection of biotechnological inventions, including the inventions related to biological material. And often this directive is used to interpret the European Patent Convention. And then something new is the Unified Patent Court Agreement and the implementing regulation. Why is this important? Because as I said earlier, European IP rights at European level are litigated. So if there is infringement, I said you have to go to national court. Now, thanks to this agreement for patents, there is already a court competent for deciding on infringement of patents throughout the European Union. However, this agreement has not been signed by all member states yet, hopefully. So this is, of course, only applicable for those member states that are part of the agreement. Interesting to see is that for member states that join the Unified Patent Court Agreement, there is a breeder's exemption provided. So this extends it also to patents. Now, the European patent system, what can be protected? Inventions in any field of technology, but what is an invention? An invention is a technical solution for a technical problem. The invention is defined by its requirements, so it has to be new, inventive, have an industrial application, and it should be sufficiently disclosed. Now, novelty, as I said earlier, is different from the novelty of plant variety rights because this is absolute novelty. So it means that the invention should not form part of the state of the art. For state of the art, I mean any document and information available to the public, even if it has not been consulted directly. So it is sufficient that something is available to the public in order to be considered prior art and in order to be capable of destroying novelty. When it's about patents, the test is always done taking into account what is called the skilled person. So this is a non-existing person, so it's an imaginary person who knows everything and who should basically test inventions according to these requirements. So inventiveness, it is considered as if the invention should be not obvious for this imaginary skilled man, considering what is available to the art in the state of the art. So basically there is a problem solution approach. Is there the technical solution to the technical problem? So is the skilled person able to solve the technical problem with the solution that is provided and given what is available in the state of the art? Then it has to be capable of having industrial application, and it has to be sufficiently disclosed. So there has to be a detailed description of at least one way to solve the problem that I mentioned. What cannot be patented? Discoveries, inventions that are contrary to the public order and morality, and methods of treatment of the human or animal body by surgery or therapy, and diagnostic methods. Also excluded from patentability, plant varieties per se. That's what I mentioned earlier, and that's why there is a sui generis system, and essentially biological processes for the production of plants and animals. Also excluded are plants and animals exclusively obtained by means of an essentially biological process. Now, what an essentially biological process is heavily debated at the European level at this moment. We have a Euroseeds position, but I will not go into that, but it's just to say this is not a straightforward definition given the most recent technological developments. Scope of protection. So the scope of protection is determined by the patent claims. Again, I don't know how much all of you know about patents, but a patent is a physical or anyway electronic document which is composed by a title, a specification or description depending on the country in which you are, the claims and an abstract, and there can be figures, but that's not mandatory. The claims are the core, so really the heart of your patent application. They can be of two types. They can be product claims or process claims. In case of a manufacturing process claims situation, directly obtained, the product can also be covered by the process claims. For biotechnological invention, the protection extends to any biological material into which the patented invention is incorporated and in which the function is expressed. That's very important because it's completely different from any other type of IP protection. And any act for which the invention is covered by patent protection, at the end requires again the authorization of the patent holder. So you see that's almost the same for any IP right. Important to say here that when you apply for a patent application, so when you request to have a patent, you will have an application fee to pay, you will have an examination fee, you will have a grant fee, and then you will basically pay when you apply for the patent if you have more than 15 claims in Europe. So it's very important to keep your claims short and straight to the point, because this will also determine the amount that you will pay. The exception, private and non-commercial use for research. Again, it's important to say that countries where you go, definition that you have of research use. At European level, there is one definition that has then been implemented in different ways and also interpreted in different ways. There have been cases ending up in court for this, of course. And for biotechnological inventions used as farm-safe seed, which is one of the exceptions that I mentioned earlier for plant variety rights. The limited breeders exemption is available in a couple of European countries and is available for members of the European Patent Court agreement. The process. So if you apply for a European right, there is one centralized, so you submit your application at the European Patent Office, you pay your application fee, and then there is one examination process made by the European Patent Office examiners, which guarantees that normally your patent application is examined in the same way for everyone applying for this type of rights. The application is published after 18 months, unless, of course, you ask otherwise. There is the possibility to do so. And yeah, you have your publication. The application is then examined to check if the application fulfills the criteria that we saw earlier. If the examination is completed, then there is a decision to grant or a rejection. Afterwards, you will have to select the member states in which you want to validate your case. This is special for patents. So when you apply for what we call the EP, when you file an EP application, you basically don't have anything in your hands, because only after the grant of your EP patents, you will have to decide where do you want to validate, and you will have to choose the countries in which your right will be granted and pay for it, of course, in each country. Of course, patents also have a different time of protection. I said it also earlier, they provide 20 years of protection. There are exceptions to that, for example, in the pharma sector, where you can have supplementary protection, but it's important to think about the 20 years. Now, I am at the end of the, let's say, legal content. What I want to say is that this has a heavy impact on our organization, in the sense that we need to have a position because we strongly advocate for the importance of having a strong IP system for our sector, and we had to renew our position or to update it this year due to the technological developments and due to the importance of recognizing that two systems exist and they have to coexist. So I will not go into details about that, but I just want to mention the guiding principles. The first, I anticipated it. It's the effective protection and practical enforcement possibilities for innovation in plant breeding. Again, as the only way to gain a fair return on investment. Access. We believe that it is of utmost importance that innovation is accessible for breeding new varieties. And we also believe that one system is not sufficient. So we recognize the importance of both plant variety rights and patents in this case, in order to cover all the needs that our sector has, and of course that our members have as well. So at the end, it all goes back to being aware about intellectual property, knowing how to use it, knowing where to look for the legal framework, and being aware that it's really, really important. So that's everything I wanted to say.
Thank you for joining us. Thank you for your discussion, and thank you, Francesca, for a great talk.
Thank you. Thank you very much. Bye-bye.
Bye-bye.